aren't trees that are in direct contact with the house also hanging over and near the house? I mean, what I'm thinking is you're like, haha, gotcha. But it doesn't really seem like that could ever have been the intent.
I don't know. As I said,
right?
I didn't type that verbiage. I've typed much better amendments. I didn't type
It's
that.
not a matter of typing.
I would never, I've never put an or in a contract at all, because or isn't contract verbiage, because it can come back to be half cute, whatever you said. I don't know.
Too cute by half, right?
Too cute and a half.
Yeah.
But I chose an option, and that's because I was given an option. I'm not trying to be malicious against anybody, just trying to handle
Do
my
you think that
contract
was the
duties.
intent when they wrote it?
I don't know.
If they thought one thing and you thought another, there is no meeting of the minds and no contract. But don't you think they meant that you have to remove tree branches that are in direct contact with, or tree branches that are hanging over? You have to remove tree branches that have either of those qualities?
No, I think or. They want and. I'm not doing both. I did or. Or is apple juice or orange juice, not apple juice and orange juice.
But what if I said to you, Mr. Pollard, remove all the juice from my fridge that is apple or orange? What do you think I mean by that?
I think remove all juice. It didn't say have trees cut back.
Don't I mean remove anything that's apple and remove anything that's orange? Is that
Apple
what
and
I mean?
orange, but if pineapple's in there, don't touch it.
Right, and that's what it says here. Remove the tree branches in direct contact with or hanging over.
Well, that's the pineapple juice. That's the or.
Look, as an English major, I think we're going to agree to disagree.
Me too. I think we were classmates.
I don't know. I think I would have remembered someone who really had me on my toes the way that you do. I think I would have remembered you.
Sorry.
I want to talk more to the plaintiffs about the issue of concealing the relationship between himself and the house sale. Because this is really what it comes down to with an as-is sale, right? If you can prove that there was some fraud on Mr. Pollard's part and that he knew about and concealed a defect, then as-is goes out the window. Yeah.
Your Honor, I believe that he's been deceptive all along.
Why?
In the fact that he put the insulation in the scuttle hole just so that if you looked up there, you took a glance, you would say, oh, there's new insulation right there. And he didn't put the insulation through the entire attic.
Okay.
And because we didn't get a chance to do a walkthrough because his things were still there.
You did a walkthrough.
Stop, hold on.
Because we didn't get a chance to do a clean walkthrough, his things were there. We didn't discover the hole until afterward.
What did you want to say?
I didn't go over the information on how they did have an inspection period about the hole in the floor.
You have some documentation?
Yes,
about
sir.
the hole?
Yes, sir. If you go to defendant side, page 3.
Yeah.
Inspection and due diligence, which is the agreed upon thing. Of course, at first they asked for 10 days, and then I extended their due diligence just, just because I'm not shady or being, I gave you more time to say no and get your money back. And it says, in the event that they do not terminate, buyer shall have accepted this property as is.
Right.
We got it.
Yeah, that.
Yeah, okay. I just want to make sure before we break up that y'all know they didn't terminate and they had an extended due diligence.
Thank you very much.
Stand up, man.
We'll excuse you both
Thank
while
you.
we deliberate in this case.
Yes, sir.
This courtroom is now in recess.
I think I have a fairly good handle on the issues. First, his either or. It was never either or.
Right.
That was not the intent. The whole idea of the language was to make sure that nothing would happen to the roof, that there was precarious limbs hanging over it, as well as those touching it. He was to remove those impediments. He didn't do it. He should be held responsible for it. As to the insulation, I saw the plaintiff's photographs. The attic is not insulated. It just isn't. He's got to pay for that. As far as the hole in the floor, there isn't enough concrete evidence on the part of the plaintiff for me to draw the inference that he was aware of it and kept it from them.
Especially if it was already carpeted. What would make him want to go over there and think that there's a hole?
Yeah.
So
I agree. I don't think there's evidence of fraud.
We have a verdict.